my list, so I won't have to do this from memory. Okay, got Andy Allen,
Here.
Mark Brudd.
Mark Brudd is here.
Okay, Reese Smith,
Here.
Keith Whittington,
Here.
Ronnie Tickle,
Here.
and Jerry Hayes.
Here.
And I believe that's everybody. Did I miss anybody? 1, 2, 3, 4, 5, 6. That's it. We got a quorum. So,
All right. Do I need to read the statement of necessity?
Yes, go ahead and please read it.
The statement of necessity, TCA 8-44-108, the Board of Licensing Contractors has canceled their regular scheduled meetings for January 30th, 2019 due to the forecasted inclement weather. However, a special called meeting of members to meet electronically has been called due to necessity. Necessity means the matters to be considered by this governing body requires a meeting in order to take timely action. A physical presence by a quorum of the members is not practical within the period of time requiring action. In preparation by a quorum, participation by a quorum of the members will be allowed by electronic means of communications. Voting would be conducted by roll call.
Okay. So, I guess from there, just go ahead and go through the agenda just like you would.
Okay.
We're here.
All right. Hardships approved by the executive director. That'd be you, Carolyn.
Yes, all these have been reviewed by a board member, and you should have received the attached list.
Right.
So you just need a motion for somebody to approve it.
This is Jerry. I move we approve.
This is Keith, and I second that motion.
Great. Do we have to do a roll call on favored or what?
Right, on everything, you're going to have to do a roll call, and I'll go ahead and do your names, okay? Andy Allen?
Yes.
Mark Brudd?
Yes.
Reese Smith?
Yes.
Keith Whittington?
Yes.
Jerry Hayes?
Yes.
And Ronnie Tickle?
Yes.
Okay.
Next, we'll move on to license approvals, waived applications. Ken, let me ask you a question on this waived applications. On this list that I see before me, what does an X mean?
Are those the ones that were been signed off?
Somebody's already looked at them, yes.
And what about the ones that don't have an X?
Because I haven't got to it yet. I haven't updated the list.
Oh, okay. I'm sorry. So they've all been...
They've all been reviewed.
Yeah, just ignore that X then. They've all been reviewed, but that's her list that she uses internally.
Okay. All right, so we could get a motion to approve the waived applications. Is that correct?
Yes.
Could I have a motion?
Keith, and I'll make a motion that we approve the waived applications.
Do I have a second?
This is Jerry, and I second it.
Okay. Roll call. Andy Allen.
Approved.
Mark Brudd.
Yes.
Reese Smith.
Yes.
Keith Whittington.
Yes.
Jerry Hayes.
Yes.
And Ronnie Tickle.
Yes.
Okay.
Now we'll move on to revisions. Do I have a motion to approve the revisions?
So moved. This is Reese.
Have a second?
Second. This is Keith.
Roll call. Carolyn?
Andy Allen.
Yes.
Mark Brudd.
Yes.
Reese Smith.
Yes.
Keith Whittington.
Yes.
Jerry Hayes.
Yes.
And Ronnie Tickle.
Yes.
Okay. Yes, has it.
Now we'll go to the LLEs. Have a motion?
I'll make the motion, Andy Allen will.
Do I have a second?
Second, Reese.
Roll call.
Andy Allen.
Yes.
Mark Brudd.
Yes.
Reese Smith.
Yes.
Keith Whittington.
Yes.
Jerry Hayes.
Yes.
And Ronnie Tickle.
Yes.
Okay.
What are the HIs?
Home improvement.
Home improvement.
Home improvement, I'm sorry. Okay. Do I have a motion?
This is Keith, and I make a motion we approve the home improvement licenses.
Yeah. Do I have a second?
Second, this is Jerry.
Roll call.
Andy Allen,
Yes.
Mark Brudd,
Yes.
Reese Smith,
Yes.
Keith Whittington,
Yes.
Jerry Hayes,
Yes.
and Ronnie Tickle.
Yes.
Okay.
Now, I guess we'll move on to residential subcommittee cases.
Did they?
Skipped over LLP, Ronnie.
I did. I'm sorry. Do I have a motion on the LLP?
This is Keith, and I'll make a motion we approve the LLP renewals.
Do I have a second?
Second, Reese.
Second, this is
Roll call.
Andy Allen,
Yes.
Mark Brudd,
yes.
Reese Smith,
Yes.
Keith Whittington,
Yes.
Jerry Hayes,
Yes.
and Ronnie Tickle.
Yes.
Okay.
On the residential subcommittee report, do we have an attorney there to go over this with us, or
You've
what?
got three.
Oh, all right. Well, I guess we're going to hit it on the head. I have 1 through 32. Go to. Is everybody ready? I'm sorry. Is everybody ready?
Yes.
Yes.
Okay. Number 3, 201-8077-871. Recommendation was for $500, and I raised it to $1,000.
Okay.
Moving on down to number 13. You had a $2,500 civil penalty, and I raised it to $5,000. Number 15. I was a little confused about this right here. I've got on my notes, it says, I got, when is he coming, and do not renew any license with his name until he appears before us. This has to do with, you want to go over it to explain to everybody?
Sure. This is, and I agree with what you just started with. The complaint came in on one name under it's a licensee, so it's not dealing with an unlicensed individual. But there has recently been a bankruptcy, and now there has been a request for a name change using the same license number that was associated with the old entity that's now in bankruptcy. So that was the reason for just discussing the matter. But that's what you just said, I believe, is what my recommendation would have been otherwise.
Okay, if you'll just find out when this guy's coming and everything, and then we'll deal with it at that time, okay?
All right.
Number 17, I raised it from $1,000 civil penalty to $2,500. And number, let's see. Moving on down the line here. Number 25. We really differ on this one. You put a $2,500 civil penalty, and I put a $15,000 civil penalty. Would you like to read that and see if I'm way off bat, if anybody disagrees with what I'm saying?
I'm just going to review it just so I can.
Okay. I think you'll probably see when you get $298,000.
All right. This is Dennis Gregory again. I mean, that doesn't. We can 15,000 is. I mean, based on the number of days and whatnot, that's within the limits of the statute. I don't have any issue with it. I'm not sure exactly what I was when I put this together, the summary together, what led me to 2,500, but that's fine.
This is Keith. I've got a little bit of input on that. This contractor's a BCA little r.
Yep.
And depending on when he got his license, do we know when he got his license? But even if we don't, or if we do, they're all well educated into the fact that they have a $125,000 limit. I'm almost in the thoughts that we need to suspend this license for 6 months.
That be in addition to the 15,000, or just a
Yes, sir.
suspension? Okay, so in addition to the civil penalty.
Ronnie, I'm not trying to overweigh what you're saying, but I'm
That's
just
right.
reading this for the first time.
I do not disagree with you at all. I appreciate your
We'll have to
input.
send a message sooner or later
Yeah.
that you stay within your 120. I was against this $125,000 limit to start with.
Yeah.
And we need to make sure that we send a message, you stay within your limit, or this is what you're looking at.
Well, that plus $298,000 plus another $90,000 to do this job at $125,000, and then you got two other people involved. I concur with you 100%. Let's move on to 26. I changed from $1,000 civil penalty to $2,500 civil penalty. Let's see if any other ones I have. And that concludes my report. Now,
I got the next one. This is Reese.
all right, thanks, Reese.
At the end of number 37, on the recommendation, we need to monitor. We need to close it and monitor the proceedings. And 40, you asked for a discussion. It looks like he built this house for a guy, and the guy flipped it, but I'm not sure the original builder is still responsible. But we need to monitor the court proceedings. Anybody disagree? Attorneys disagree with that, or? Okay. 42. The licensee needs to get a letter of warning, and then we will monitor the litigation. He exceeded the license limit of the licensed contractor.
At 42, Reese.
42, yes, sir. Okay. I'm back to 47. We need to close and monitor the court proceedings. Let's see. It looks like 51 at the very end. I said we need to monitor the payment. I think he has a payment plan there. We need to make sure that he completes his payment plan somehow. I guess monitoring the litigation.
What number was that?
51.
51. And on 53, I think you recommend, or we should not close that because it looks like you're going to send out a second investigator. I guess what I'm saying, do not close, send a second investigator as one of your recommendations.
What was that number again, Reese?
53.
53. Uh, 55, I would close. 55. And I'm good.
Thank you, Reese. Keith, you're up.
Okay, I've got starting
Hold
at
on just
60.
one minute. I see a term here that I think I know what it means, but I wanted to ask. It says the license has now reached an expired grace. I think I know what that means, but tell me again what expired grace is.
Means
It's in 61.
it means but they have renewal rights for a few more months, and they haven't renewed as of yet. So expired grace means they still have renewal rights.
Okay. All right. I'm finished then.
Thank you, Reese.
Guys, I start at 65. The first one I've got a thought on is 67. The recommendation was to reduce the penalty to $1,000. Not sure why. I think we need to keep the penalty the same. Why would we reduce the penalty?
My thought was, this is Dennis, my thought was at once that I spoke with both parties, both the complainant and the contractor, that originally we believed that he had done more in terms of moving the drainage pipes to these ponds. Apparently all he did was just do the dredging. Now the dredging would be, under the definition, would be like excavation, so I agree it was still contracting and he was unlicensed. So that was just my thought.
Yeah, he's jumping across the state line to get what he can get, and I think we need to leave it the same.
Okay.
68, I've got for us to discuss. Two separate projects. This is one contractor. He's worked at a complainant's home. Then he worked at a church where the complainant was a member. And apparently he's walked off the job on both of them. We were going to do a voluntary revocation. His license is expired. And we were going to do a $10,000 penalty, but apparently, for whatever the reason, we can't do a $10,000 penalty. Is that because of the license being expired?
That's my understanding. This, Dennis. Yes, that's given the fact that it looks like we're coming up on 2 years. I don't know if there's any issues about service of process or notification if it were to go to formal hearing, or even there's been any issues trying to get the previous consent order there.
I guess I'm asking why we're at a 2-year point now. Have we not caught up with our cases yet? Or is there some other reason this case is drug out?
We could probably table that one. That's it happens to be handled by another attorney that's outside the normal case flow. So if you want us to just, before we break, we can find out a little more information on it.
It would be good because, here again, we're trying to get current on our cases where things like this don't happen. I don't know exactly when this was presented. We need to know things like that and why we're 2 years past the guy and his license being expired and didn't take any action.
This is Ronnie. I agree, Keith. I thought we were getting on top of this
Took
thing.
some action at one point in time, and then it got deferred or whatever. And I don't know why.
All right, we're going to send a message up to the other attorney that's handling it. We'll
Okay.
get you an answer.
We'll pass on that one for the time being. I've got 71. I agree with. Wait a minute. Am I looking at the wrong one? And I agree with 71. We get over to 73, and I've got discuss. But
Okay.
I'm looking at it as a. Well, I'm going to agree that we need to turn it over to the local district attorney's office. But I also think that we need to do a civil penalty if we have a service address for unlicensed home improvement to the max that we can charge.
Dennis, what's the max we can charge?
Well, it's $1,000 per incident. Now right now we just have some evidence that being the screenshots I referenced in the summary about a roofing job. So $1,000 for unlicensed home improvement is what it is for one instance. We could conceivably, this would push us farther back. We could send an investigator out to maybe see if we could determine how many other jobs he's had, but $1,000 would be easy enough just based on what we have currently.
Then I think we need to proceed. To send an investigator out is, like you said, it's just going to drag it out further, put the case further from settlement, and less likely to be resolved.
So we're going to turn it over to the district attorney and get a civil penalty of $1,000. Is that what your recommendation is, Keith?
That's my recommendation.
Okay. Dennis, how's that?
That's fine. I mean, I guess looking down the road a little bit, we might see it again at some point, depending on whether or not the DAs. And you all know sometimes they will cooperate with us, and sometimes not. So that's fine.
It might look good on their part with the DA if they do cooperate with us. I'll move on now to 75. You've got a recommendation of a $700 civil penalty. Where did $700 come from?
Well, the max being $1,000.
Then let's go to the max at $1,000. And moving on to number 86 will be the next one. You've got a recommendation to close and flag as the license will expire in February of 2019. Can we not go ahead and do a revocation now? Do we have to do something special? Can Carolyn not revoke the license and not allow it to renew?
Well, we can't, I mean, without a voluntary revocation, no. But by the end of February well, yeah, based on next month, in the next month.
I know it's just a month, but I was trying to put an end to this. They may be out there doing the same thing to other people.
Well, other than other than the summary suspension option, that's going to be about it. I mean, with the revocation, they still would have a right to a hearing, and 90% chance we wouldn't have a hearing for probably middle of the year. Yeah.
Yeah. Then can we make sure that this license is not allowed to renew?
Yeah, we flag it, and they can either come in at the next meeting or not. Yeah.
Okay. Then that's where we'll stand. We'll not renew it until they appear before the board. That will be my determination on that one. All right, and I'm good on all through, let's see, 89.
And I believe that you would have this one as well, Keith. 91. We had this is 2018-07-7351. We had a request within the last couple of days for an inspection on that property, and since it's a licensee, we can send an inspector out for that, and I think it'd probably be best to do it. We're not going to go over 180 days, so my recommendation I know I have closed and flagged, but I say let's keep it open and allow the inspector to go back out, or allow an inspector to go out. We've never sent one.
Well, it said the respondent claims that the work was blessed off on by the complainant, but the respondent was not licensed to perform the work anyway.
Well, they wouldn't have been up to you're right, that amount. Although they hold a home improvement license, so arguably,
then they're in violation of the home improvement law by going over their limit. So what we need to do is put a $1,000 fine on it for over limit, and go ahead and have it looked at. We let people get off too easy anymore, and it needs to stop. But back to 89, I was looking at 89, and I think we need to do a $1,000 civil penalty on that one as well. And the only other one I had another question on, Dennis, was number 94. And I understand everything here. We had a failure to renew, and that's probably because they got service somewhere down the line. Did we know if they actually got service?
No, the only thing that I can tell is that they're out of business. That may be likely. I don't. This just is my guess, given what she's done in the past. Ms. Brown may have tried to contact them or had contacted them, and they said that they're no longer in business. But
can we not turn someone like this over to the Attorney General's office and let them pursue it?
Well, it'd be more like turning it over to the local district attorney. The AG's office might potentially send it back to us, as most referrals that we get usually come from them to begin with, if someone has initially contacted the AG's office. So if anybody else outside of this agency was going to handle something, I'd say it'd be the local district attorney.
I just, people can come in and violate the law and mess up people's lives and houses and go out of business, and then we just stop. And I think we need to keep something on their trail. The IRS wouldn't give up on them. And if we've penalized them, it needs to be turned over to somebody to go collect it. That was just my thinking. That was why I wanted to bring that up for discussion.
Okay.
Keith, this is Ronnie. I agree 100%.
That's all I've got.
Thank you, Keith. We have no further construction on residential. Let's move to commercial subcommittee.
You want to?
If I can just address the board, this is Ashley Thomas. I know on the residential legal report, there was a question on, what number was that, Dennis?
68.
On number 68, and the assigned disciplinary counsel for that case has joined us. Her name is Erica Smith, and I think that she should be able to answer any questions you might have.
Hi, this is Erica.
Erica, this is board member Keith Whittington. I'm getting back down to 68 for you. We've got a recommendation here to close and flag. The respondent's license has been expired since May of 2017.
Yes, sir.
And I'm wondering what has happened to this case that it was originally presented to the board. The board made a decision for voluntary revocation and a $10,000 civil penalty, and it's taken 2 years or longer since that was presented to the board, and it still never was adjudicated.
Well, I can see here the history. The original recommendation was voluntary revocation and a $10,000 civil penalty, and then it was represented by another attorney before it was transferred to me. And I guess the board decided to dismiss the civil penalty entirely and only ask for voluntary revocation. And that was all before the case was transferred to me, which it was transferred not that long ago. And since he no longer has a license and there's no civil penalty, and we can't revoke it, there's really no discipline that we can assess unless he wanted to do something new. I can't speak as to why it took that long. I can
that's why I'm confused about it, and I'm also confused as to and probably know the reason, but the board made the second decision to accept the recommendation of legal counsel to dismiss the civil penalty and just do a consent order for voluntary revocation, which tells me at the time he was still licensed. And we've gone on so long. Oh, we were going to give a formal hearing. And in that formal hearing, we probably could have, and that's probably what the board was thinking, if we want to do a civil penalty, we can do that during the formal hearing.
Right, and that's still the board, the board can still make that decision. Just be aware that there's no license to revoke.
There's no license to revoke, but why can't you give a civil penalty anyway?
We can. We would have to reauthorize a new civil penalty and offer that in the form of a consent order. I believe we'd have to do that first before we could take it to a formal hearing. Is that right, Dennis?
Well, I mean, assuming that this individual, we have to go back and just look at the literally what's in the file. And if he received, if the licensee or the the respondent, he's not a licensee now, respondent received the consent order, there's already been the the requisite notice, so we could just go right to a hearing. Then the only thing you're up against is just being able to get good service on them, that would satisfy whatever ALJ that was assigned to the case.
And what if they signed, once I file a notice of hearing, if that's where we went, what if they signed the consent order for voluntary revocation with no civil penalty? Is that an option for the respondent to avoid?
Well,
there's still a consent order out there.
I guess the best case scenario is that he signs a consent order with a $10,000 civil penalty and actually pays it.
Well, it was voided.
Or it was voided?
Mm-hmm.
Okay.
That's the thing. So I guess.
Why would he pay it if he doesn't have a license?
Well, that is another way to look at it. That for him there's no incentive, or either he just cares less at this point, right?
Yeah, but if we do like I was speaking to earlier, and choose to not let this go and turn it over to the local district attorney for service and process, it just seems like every decision that we make here is based upon whether they're willing to do it or not. They can just go out of business and let their license expire, and we just forget about it. And right here, they have taken that church for about $41,000. They took the first respondent for about $7,000, making it a total of $48,000 he'd done something with. And I think we need to pursue it until we can't find them anymore.
We can refer it to the district attorney's office, because if we were to get a civil penalty at a formal hearing, as far as I know, it wouldn't go to the complainants anyways. Is that correct, Dennis?
That's right.
That's right.
So it would be more likely for them to be able to get some of that money back if we referred it to the district attorney and they pursued it.
They'd at least have some option for restitution, right?
And whereas we don't.
I think that's what needs to happen on all these cases, that we keep closing and just saying, okay, well, we can't get them. They need to be found and required to pay. They'll find them.
So I could revise the recommendation to, would we close it and flag it on our end just in case they ever try to get a license, and refer it to the district attorney's office?
That would be satisfactory with me.
Okay. So I will revise my recommendation to that.
Thank you.
You're most welcome. Thank you for discussing that.
If there's not any more discussion on residential, let's move on to commercial subcommittee cases.
Right, this is Mark. We've got cases 101 through 104, and I was in agreement with all the recommendations for those 4 cases.
This is Jerry, so was I.
Commercial subcommittee agrees on all 4 cases that they had before them. Is that correct?
Yes.
Yes.
I make a motion we approve the legal report as amended.
Do you have a second?
That's second.
Roll call.
Andy Allen,
Yes.
Mark Brudd,
Yes.
Reese Smith,
Yes.
Keith Whittington,
Yes.
Jerry Hayes,
Yes.
and Ronnie Tickle.
Yes.
Okay.
Do we want to move now to the Construction Management Incorporated suspension discussion? Or
Hi, this is Stuart Huffman. I believe y'all know the facts in this case, and also that Attorney Pulley and Mr. Colson is on the line. Is that correct?
Yes, we are here. Can you hear us?
Yes. Can all the board members hear them?
Yes.
Yes, but I might need a review of the facts.
Basically, this is the case where construction management had a monetary limit of $284,200 and was using an alleged fraudulent letter for unlimited monetary limit. And they built several hotels, pulled multi-million-dollar permits. Okay. Construction management has recently offered to increase the civil penalty on the settlement agreement, the proposed settlement agreement, to $80,000. And I think I'll let Attorney Pulley go ahead and discuss.
Thank you, Stuart. Yes, we at our last teleconference a few weeks ago, I understand the board had some concerns about the amount of the fine. So we have increased the proposed fine from $50,000 to $80,000. One thing we do want to make clear is that Mr. Colson has lost a lot of business by not being able to work on several hotel projects over the last few months, and that's a consequence of what happened, and we understand that. But we do ask that when you're assessing the fine that we have proposed, to assess it in the context that Mr. Colson has probably lost a couple $100,000. He is here today, here in Nashville. We're in the same room. If you have any questions of him, he definitely he'd be glad to answer them.
This is Ronnie Tickle. I did a little investigation, had Carolyn do a little investigation. I've been concerned about this case since the last time we had a phone conversation, and we can't find where any license was that Mr. Colson had a license under Colson Carpentry in Rapid City, South Dakota. That's the only license that we found in his name, and supposedly work was done in 24 states, and I'm just trying to figure out how you can do work in 24 states without license. And I'd like that explained. And Carolyn, I know that you did a lot of work after I called you in regards to this. Am I correct in what I'm saying, Carolyn?
Yes, you're correct. I couldn't find any record of any other license held so under those names. So
I just kind of like this explained to us.
Okay, this is William Colson. Colson Carpentry was that is a business that I had in several years ago. I did small remodels and stuff. Just the history of who I am and where I came from, it was while I was doing Colson Carpentry, I was in a Gillette, Wyoming, doing a hail damage on a few homes, and I was staying in a hotel, and I ran into a project manager for a hotel building company that was remodeling the hotel I was staying in. That turned into my career of building hotels. This was over 20 years ago. I've been building nothing but hotels from that moment on. I worked for a company called Hospitality Builders for the last 12, 15 years. That's the company that I was with, that we built hotels from coast to coast. I'm part of over 100 hotels with that company. The reason for my split off to start Construction Management Incorporated is because the main partner of that company, his name is Frank Gould. He was on the ground floor of the Super 8 chain out of Aberdeen, South Dakota, was selling his shares to the other two partners. When the other two partners bought those shares, they decided they were going to go in the direction of self-build. I was more of a fan of how we were operating as far as building hotels around the country. Now, I do hold a license in the state of Colorado right now. We pull our licenses as we build these hotels in these different states. We don't keep them current if we're not building in that state. We reapply when we go. Most of my licensing and everything was through the company of Hospitality Builders. I did the tests, I did the licensing, I did all of that stuff. A lot of them were in the company name. A lot of them there were some that were in the registering agent's name. So there's not. I mean, that's the best explanation I have for that.
Were you an employee with Hospitality, or were you one of the owners?
I was an employee there. I was a small shareholder, but not enough for the books. I think it was under 7%.
That would explain the reason why we couldn't find a license.
I agree what you just said there, Carolyn, but that's not how he actually talked to us on the last meeting.
Yeah.
We got a little. It's a little different. It's a little different talk today than when it was on our last telephone conversation.
So what are they asking the board to do?
Well, they're asking for to reinstate the license, pay the civil penalty of $80,000, and then also there were some other requirements that construction management would do to notify the board of any bids, commercial bids, things like that in Tennessee.
And how long has the license been suspended, let's say?
The end of November.
This is Mark Rudd. Have we received an application from them that would qualify them for an unlimited license?
No, we hadn't. What we have received, I've got something in front of me. They were asking for $2 million. I say I had it in front of me. $2 million and something.
I think it's $2.4 million is what they qualify for.
Yeah, based on their what they sent in to us, the worksheet. And that's what they wanted to do. They wanted us to give them a new license, forget about the $280-something thousand license, go with a over a $2 million license. Is what they wanted us to do. And forget about the fraud. That's what they wanted us to do. Remember, forget about the fraud.
If I can, this is Matt Pulley again. We're not asking you to forget about the fraud. What we are saying and what we have said in the past is that we take responsibility for that, but this was not done by Mr. Colson himself. He has a company that has 15 to 20 employees, and he thinks it was one employee who was recently fired, but it was not Mr. Colson. Mr. Colson did not alter the letter.
And we're supposed to believe that in a small 12 to 15-person company, one person just took it upon themselves to commit fraud.
In any company, you have an employee who, it's not unlikely in any company to have an employee who doesn't act appropriately. I mean, this is not something that Mr. Colson has ever dealt with before. We have policies and procedures in place that we are proposing where this is never going to happen again. Every single communication with the state of Tennessee, Mr. Colson is going to look over personally. He's had an impeccable record in this industry for over 20 years. This is an anomaly. He understands the buck stops with him. Mr. Colson understands that, and that's why we're offering to pay an $80,000 fine. But I do want to make clear, this is not something that he knew about, and obviously not something that he participated in. His record is spotless.
This is Ronnie. I've got a company. I'm a commercial builder, residential builder, and I'm licensed in I'm only licensed in 3 states, but I carry my license. My license are posted on the board on my wall where I know what I can do in each state, as well as my business license for every city that I'm in. where I can look and see directly what's going on, and I can't understand how come if you're building a $6 million project and knowing that you got a $280,000 license, how in the world can anybody think that somebody can do that when you only have a $280,000 license? I can't get that. I don't understand, and I think that's what some of the other board members are thinking too.
How much was the permit that was pulled for the hotel in Murfreesboro?
It was to be $8 million.
And he's only applying for two license now? Okay, I get it.
We didn't pull that permit in Murfreesboro. That project has gone to someone else, along with several other projects that have gone to someone else. To answer the question on how I got the licensing was, I initially filled out all of the paperwork with my office manager at the time for the license in Tennessee. When the monetary limit came back at the $284,000, we resubmitted several different items to the state of Tennessee through my office manager at the time. When my office manager at the time showed me that we had that it was, after we submitted all of the new stuff, it was the communications went back to my office manager. Her name was Lori Benson. When everything went back to Lori Benson, it was a couple of weeks later that she produced this letter that we used as an unlimited license based off of the $284,000 license. Did I question that? No, I didn't, because I know that what I went through to give her the items to resubmit to the state, which I'm pretty sure she did, whether they qualified or not. That's what my office manager does. I make them qualify for all of this stuff. My current office manager does the city license, the county license, the state license, the taxes. We have a pretty extreme list of what our requirements and everything are. I have to put all of my faith into all of those people in my office to do that. I surround myself with them. Moving forward, I question everything that comes into my office. Ronnie, I understand what you do with your license and with your tax IDs and all of that stuff. I am moving forward doing the same thing. I did not do that up front. We had so many parts and pieces movement up front when we were moving forward, starting the company and starting to come out with this stuff, that it did slip. And I'm taking full responsibility for it. I don't want to move on without any punishment, without any lessons being taught to me. This is a huge lesson that's being taught to me. I'm taking full responsibility for every action my company has ever done. We have zero consumer complaints. We have zero subcontractor payment complaints, liens, any of that. We operate almost flawlessly, other than what we did here. And I'm here in front of you to state that I'm willing to do what I got to do to make it right with the state, to make it right with my customers, with current, future. However we move forward, I haven't gone away. I could have gone away, but I'm still here. I'm still looking to make this right. I didn't take anybody for anything. I've paid every bill that ever came our way. I've paid every employee, every subcontractor, every state tax, city tax, county tax. We're not a fly-by-night company. I see what Caroline's looking for, and why she can't find the Colorado one is beyond me. But I could produce it. It's killing me, and I know it's killing you guys too. It's hard to explain. It's hard for me to even understand it as well. But I've got amazing credit. I've got amazing status with all of the people that we've worked for. I don't know. I'm beside myself with it, and I just want to do what you feel is right for me to do to move forward.
Well, this is Ronnie again. It appears that I believe in one of the things you asked, if you could join with in the event you were granted the $2,366,480 new license that you would like to be able to enjoy with another contractor if in fact you were able to get another project that was over your limit. And of course we have that where somebody can do that. But again, it's just hard to grasp what has happened. I guess that's what I'm saying. But it's tough with employees. I understand. I've got them too. We all have them. And without our employees, we wouldn't be a company. So,
one thing we are proposing is that every single communication that construction management makes with the state of Tennessee, any sort of permitting board, any communication will be provided contemporaneously with the state. So we have proposed measures that are going to make sure that this absolutely does not happen again.
This is Ronnie. Can we have any comments from any other board member other than Keith and I? Anybody?
This is Mark Rudd. Is the financial statement that we have from their application an audited statement or a reviewed statement?
No, it is a revised statement.
Reviewed, yeah.
Isn't that correct? Revised?
Yeah, we have a review when...
reviewed, I'm sorry. Oh, this is a reviewed statement.
And we also received an audit, but it did not have enough, I think it lacked more net worth, so it didn't qualify.
I'll give y'all a quick summary of what just the main thing. What we look at, current assets is $6,541,374. Is assets. Liabilities is $6,289,230 is liabilities, with a net worth of $252,144 is what I'm showing here in front of me. So, and then on the right-hand side, they're asking for $2,366,480 license. I mean, if this had been sent in originally, we wouldn't be talking, I don't think, except being over the limit, and hopefully he would have done something with somebody else. I don't know. But he did. This is cleaned up now. But I think the first thing we've got to do is decide what we're going to do on the original problem that is before us.
Did we have a time limit on the suspension? We just suspended the license, period?
We were going to try to decide at a board meeting. We were going to try to decide something at this board meeting. I don't know, Reese. I don't know if you were on the call or not when we had it, but this looked too heavy for us to talk on the phone when we tried to do it, a month ago or 2 months ago, whatever. And
he appeared at another board meeting.
I'm sorry, what now?
And he appeared at a prior board meeting.
Yes, yeah, that's correct. That's the one Andy. That's the one that Andy held, and that's what I was telling Andy. I thought he did a great job on it.
Well, I'll throw something
This is Andy
out
there.
Andy, go ahead.
This is Andy. I just got a quick question so I can wrap my head back around this. The hotels that he were doing were about $6 million projects. Is that correct?
Yes, they were. They averaged 6 to 8 million. I think the first one he did in Nashville was the permit was around 8 million.
Okay. And the reason that he's wanting to get his license reinstated is to do similar hotels. Is that correct?
Yes.
Yes, that's
okay,
correct.
But you don't have an audited statement saying that you can do that much. So to this date right now, the only thing that your reviewed statement would show would be a $2 million something license. So you're still not up to the $3 million mark. So it does no good to reinstate licenses because you're still going to be over your limit.
He can joint venture.
He's joint venture. I think that's what probably he'll end up doing. This is Ronnie talking. It's one of those things. I'm assuming that would take place.
Yes. Also, I would like to just add the fact that the reviewed financials that are in your possession right now, I have auditors in my office that are turning the reviewed statement into a 2018 audit. I will have that audit within the next month. I just sanctioned it. It's tax time. It's a tough situation to get those guys to give me that audit. But I will have the audited financials within the next 6 weeks.
Will it be better than this one?
Yes, it's going to be a lot better than that one. I think the reviewed audit would actually qualify me for the unlimited. That's what they're telling me as of Monday this week before I left.
No, that's incorrect. Your reviewed audit does not qualify you.
No, my reviewed one does not, but the actual audit, the reviewed audit was shy 3 or 4 months.
Okay.
So the actual audit when I receive it, that's just talk right now. I understand that until the paper is scanned.
Reese, go ahead and continue your thoughts. I think I'm
I don't know. I mean, just to move it along, I would consider for our discussion and then possible motion that we accept his $80,000 fine and that his license is suspended for 6 months, starting the day that we suspended it, which sounds like a couple of months ago. It would still be suspended for another, whatever that is, 4 months. And then he'd have his audited statement, and it is what it is. He qualifies for whatever he qualifies for. It's just a thought.
Do I have any other thoughts?
No, I think Reese is probably, in my opinion, headed down the direction that I was leaning toward. This is Keith.
Jerry, what are you thinking?
This is Mark. I would
Go
be
ahead,
in
Mark.
agreement with what Reese proposed.
Andy?
Sounds good to me.
Jerry?
I'm okay with it because normally once you get a license, it's kind of, isn't it? I don't know if it's written on the wall or anything, but don't we normally wait 6 months before you could raise it anyway? So,
yeah,
I think that's probably the way to go.
Reese, do a motion then.
Okay, I'd make a motion.
We would, if I can interject, and I understand the board's concerns. The issue with the 6 month suspension is that after 6 months, Mr. Colson will not have any projects that he can bid on. He only works with 2 particular families, and they are scheduled to break ground on several projects, and have already broken ground on several projects over the last couple months. After 6 months, they are not going to be opening up any more hotels. So a 6 month suspension is essentially a death sentence.
Well, it's actually about 4 months. And do they have a building permit on those hotels they've broken ground on?
Yes, they do. They moved forward with a different contractor. Brooker is the name of the contractor.
Then you can't participate in that anyway.
No, sir, I cannot. But there was 2 or 3 more other ones that they were that are in the works with drawings that they will move forward with here in the next month or so. And I could participate in those if I'm allowed to. If I'm not allowed to, they have no plans of any future hotels after that.
Well, in my neck of the woods, it can take 3 or 4 months just to get a building permit if they're just working on drawings.
No, I understand that. What I mean by what they're working on drawings is, do they have the drawings submitted for reviews in the city? two different spots. One of them is in Smyrna, Tennessee, and the other one is in Columbia, Tennessee.
Then I'm going to ask the obvious question: if, with your knowledge as well as you do of these projects, have you participated in a bid process?
No, I have not bid on any of those. We have not solicited any bids, nor have we bid.
Well, how have they managed somehow or another to turn these in for review without any bid process?
Well, that's kind of a standard thing that the owners do. They hire their architect, they hire their own civil engineers, they work through all the plans, they get a set of plans, they submit them for review, and then they send them out to bid. We have not received any reviewed plans from this yet, but once they submit to these cities and franchises, they get red lines. Once they get red lines, they send them out to get a contractor, to get numbers.
It's easy for me to say, but if they really, really want you, they'll wait on you 90 days.
I understand.
Do all kinds of dirt work. They can get a grading permit, and that's, with the weather that we have, it's going to take 3 or 4 months before you could even start construction.
I fully understand, but as you were just saying, I cannot even discuss with them for 4 months the possibility of moving forward to, and otherwise I'll, that's breaking the rules too. And I'm trying to get right with rules that we've already crossed the line on. So I mean, I would just be at a loss with the 6-month suspension.
Reese, go ahead with your motion.
My motion is, and I'm going to change it a little bit, guys, and that we would go back to our $50,000 penalty or fine, and the license would be suspended 6 months, starting with the day that we first suspended it.
Do we know what that date is?
November 28th is what I have.
It would have been November 27th. That Tuesday, November 27th.
I second that motion.
Reese, this is Ronnie. My understanding, you're removing the 80,000, dropping back to 50. Is that what you're? Okay.
Yep, since we're holding it 4 months.
Okay. And Jerry, was that you that seconded it?
It was.
Is there any further discussion? All right. Call for a roll call.
Okay. Andy Allen,
Yes.
Mark Brudd,
Yes.
Reese Smith,
Yes.
Keith Whittington,
Yes.
Jerry Hayes,
Yes.
and Ronnie Tickle.
Yes.
Yes, all in favor.
We're basically talking about 4 more months delay before he can do anything. And you said it's going to take another month anyway to get us the audited statement. So theoretically speaking, we're only talking about 3 months at the most. Mr. Polly, do you understand what I just said?
Yes, no, I understand. I mean, we're under the impression, though, that he could, if his license theoretically were reinstated today, he could still, through a joint venture, work on a project, work on a hotel project.
If it was reinstated today, that's correct.
But the fact of the matter is, it will not be.
That's correct. That's correct. Also, unless he went under, that's correct.
Is there any measure? Is there any possibility where he could still review bids during this interim? He could get a special sort of waiver that would allow him to review bids so that he could hit the ground running in 4 months.
I think that's the purpose behind the suspension, is to prohibit that.
Okay.
This is Ronnie again. I understand the what he's going through, but there again, as to what Reese said, if we've been working for the same group of individuals for a while, they're going to wait on him if they really want him, because he sounds like he knows what he's doing. He's ready to go forward. Whoever he's working for should appreciate him and wait the additional 3 months or 4 months to go forward. He'll find out. He'll find out real quick if they really love him.
Yeah, this is William. I have found out already if they really love me. I think it comes down to business, guys. They're going to move on without me. I think anybody would, and I guess the love was on my side on them guys, which is fine. It's understandable. I get it. My thoughts were if I could have got my license back today, I would have had a shot at maybe retaining a couple of those buildings. They're a great family to work with. I have for quite some time now. As I said, there's two projects that we had in discussion with the Lebanon project and a Murfreesboro project, and as I told you already, they've already moved forward with another GC. I'm probably at this point, I'm without being able to move forward on any other ones for that particular family. I'm just I don't know how to put it, but just another number in the Rolodex by now. I hate it. I don't understand it. I feel with you guys, with what I've done and who I am and what I've been with these families, they would wait for me and hold off for me and make move on. But the economy, the way that it is, the way things are, they're move. They can get higher ADRs. They can get there seems to be some sort of a slowdown in construction based off of what it was. There's a little more availability, and I think they pulled the GC for those two projects. I'm assuming that if I'm out of the running, they'll use him for the next ones too. It's just business. It's the way it works with everyone, I guess.
Ronnie, we got one more item to discuss.
Okay. The next item is a request for board opinion bid envelope listing.
Yes, I've asked Mark to lead the discussion on this because he would he'd understand it a lot better. And Mark, did you get the documents this morning?
I did.
Okay.
This is a situation that 3 general contractors bid a job. There was a geothermal component to the project. 2 of the 3 listed a contractor that's not licensed to do geothermal work. They listed his license number as a license number that a different firm had, and therefore the third bidder that did it correctly has filed a complaint. We have since been informed that I guess it was the low bidder had corrected his bid form within 48 hours to list the actual firm that's going to do the work with the license number that he had listed on the bid form before. And it appears to me that everything is okay now. We didn't have that information until this morning, and therefore we were thinking it was going to go the other way. But Carolyn was able to obtain some information this morning that said the low bidder, had modified his bid within 48 hours, and it was basically a technical error. So I think our ruling needs to be that it is okay to award to the low bidder.
Hey, Mark. It's Andy. I just got a quick question. Reading the rules here, did he use another company's license to do this, or did he just mess up the number?
Well, when he listed his subcontractor, the explanation I've got is that he is subbing it to a company who is then subbing it to a geothermal contractor.
Yeah.
And he listed the geothermal contractor's license number, but he identified the company that he was subbing it to as the company he's really subbing it to and not the geothermal company. So that's where the confusion came in for him.
So it would fit in this like a transposition of license number or typographical error. He didn't switch companies on this.
Correct. He listed the sub that wasn't licensed who was going to sub the work to a geothermal sub, and then he listed that sub's license number. So, somewhat complicated, but I think that you can understand how he got to where he was.
Well, the main thing, everybody's happy, right?
Yes.
Okay.
So, Carolyn, are you going to issue our opinion then?
Yeah, I'll do a letter and let them know today that, do you think we need to vote?
Yeah.
Okay, I guess we do need to go ahead and vote just to make it a formal opinion. And so I guess I'll need a motion that.
I'll make a motion that we agree to allow the bid form to be altered for a minor correction.
Second.
That it's appropriate to award to the low bidder.
I second the motion.
Roll call.
Andy Allen,
Yes.
Mark Brudd,
Yes.
Reese Smith,
Yes.
Keith Whittington,
Yes.
Jerry Hayes,
Yes.
and Ronnie Tickle.
Yes.
Okay, I guess has it. And I guess
We've got rescheduling the meeting, but before we get to that, can I bring some new business or old business up before we schedule our meeting?
I've got one little thing too, Reese.
All right. Reese, is it all right if Reese and I talk?
yes, go ahead.
Hey, Reese, you go first.
No, I think by the rules we're supposed to elect officers today, and if we want to wait till the next meeting, that's perfectly okay. I just think the minutes need to reflect that we did wait or we did elect, whatever we decide.
Yeah, we just put on the public agenda that we were going to just address immediate action. So I think we'll just wait until we have a physical meeting.
Okay, as long as that's noted.
Okay.
Carry on.
All right. I've got a letter dated December 1st, 2018. I guess all of y'all got the same letter, and y'all were at a meeting. A lady by the name of Tanya Radic, R-A-D-I-C, appeared before the board and asked questions that I think a lot of us have asked amongst ourselves of why our fines are so low. And it does kind of look like, if you do something bad, it's not a big deal. And I think that kind of reflects on how some of us are feeling on this and have felt. And but we just didn't express it like this lady did as such. And I think she's got valid points. And I think that's something that our attorneys need to look into about how lenient we have been on our fines. We just need to be a little bit more tougher, and like Keith said earlier, maybe we get a little bit more teeth out there, and people be doing things right instead of how they're doing it. I just wanted to put that in front of the board.
And she did appear at the meetings and did talk to the full board as well. So,
does anybody have any comment on that, or?
Ronnie, this is Keith, and I got a letter from her as well. I'm sure every board member did. And we tried to to explain to her that, most of these penalties are, and attorneys, correct me if I'm wrong, but they're set by the legislature, or do we do it by rules?
The limits on the civil penalties are set by the legislature.
And that's what I thought, and that's what I told her, and told her that that's the way she needed to work. But I can't help but also feel that if the board approached the legislature with a request, would they not at least listen to it? Carolyn, what are your thoughts?
I'm sure they would listen, but I think our penalties, the way they're set up, since they can be assessed per day, that you could probably, you should have lots of leeway, is what I'm thinking.
Yeah,
Now, can we do a per day on a home improvement?
So the way it's written, it does say per violation. If you determine that each day is a separate violation, that gives you the leeway to assess a penalty for each day that they violated.
Then maybe it's the board that's not putting enough teeth to it.
Yeah, I think this, Ronnie. I think you're probably right. We probably need to start looking at things a little tighter, and our attorneys have been doing a real good job about reading and coming up with a figure for us to look at. But if y'all would look at it and think a little bit tougher, I think it'd be nice for us to feel better about how we're treating the public. That's all I have to say.
I make a motion.
Go ahead, Keith.
I was just going to make a motion that we adjourn.
No, you can't.
No, we can't. We got to reschedule our meeting date.
Oh.
Yeah, you were close. All right, when's going to be our next meeting date, Carolyn?
Well,
we've got to decide if we need to meet prior to our next March meeting.
yes, Kathy has a lot of interviewees, about 20, and we need to figure out some way to get them interviewed and approved, because I believe March would be way too long and would cause a hardship on some of them, and especially Kathy.
Well, let's do it sometime in February.
Okay.
Do you have to have a whole board, or can several of us come down for the interviews and then report to the board?
I don't see why you could. Yeah. Yeah. We could, whoever could come and interview, we could set up that way and then do a conference call to vote on those approvals, to get a quorum to vote.
Just a thought. Are there 20? Is that a pretty good number?
Yeah. 22.
Well, if we get 3 of us that are around here, maybe Randy can jump back in. That's 5 or 6 apiece.
Yeah. That would be you and Randy, and I guess who else is close? We don't have anybody else in Nashville anymore, so I guess you and Randy could do all of them.
Yeah.
Reese, I appreciate you. I appreciate you stepping forward, buddy.
We'll work it out.
This is Ronnie. Okay.
I might have to buy Jerry's lunch to drive up here.
Yeah, Jerry, we'll do that.
I recommend double pay for Reese.
Or would y'all want to do?
And Carolyn, you send out
declaratory
some dates for the 3 of us to come up there about 10 o'clock one morning.
That's great.
Good. I can come up there.
All right. Thank you, Reese.
Okay, I'll just get
And
with
Jerry.
y'all on a date. Is there a date you want to put it on record, or you want me to just post it later? Yeah. I'll get with you all a date, and then we'll post it on the website. And then Ashley has one more thing before y'all can vote to adjourn.
Okay.
And just briefly, I received a petition from an attorney requesting a declaratory opinion from the board. So of course he wants it as soon as possible. But the issue with that is that we have to try to figure out when we can get an ALJ in. If we are not going to agree on a day today, I can just let him know that we will try to have that discussion on the record at our next scheduled board meeting in March.
What are we trying to get an ALJ in for?
For the declaratory opinion, by statute, we have to have an ALJ present because it does fall under the UAPA. And just
what is the case?
Well, it's not a case. He's asking for clarification on the board's interpretation as it relates to spec homes. And just procedurally, we have to have an ALJ present to issue such an opinion.
So in other words, it's similar in nature to a formal hearing that we're going to hold to issue an opinion.
That's correct.
So we could do it at our next board meeting if we have to stay an extra day or whatever.
Okay.
Hopefully not, but whatever.
Okay. It shouldn't take that long. I do have his particular request, and I can have Carolyn send that out to you all so you can kind of look at it and be thinking about it. And then when we meet again, it sounded like we're just going to wait until March. We're going to do the interview separate. We can have the formal opinion issued at that point.
Yeah, that'd be good if you can get it sent out to us.
If it's all possible, we can schedule it that day of the meeting.
Okay.
Rather than wait till a second day. Most
Right.
of the time we're through by 12:30 or 1 o'clock anyway. We can go right into that particular part of the hearing. And if you think it won't take long, then that's not a problem. Now, if it's going to be a days long.
And I don't believe it. I don't believe it will take that long. It's not a contested case. Like I said, he's asking a question. He needs just the board's interpretation of the law as it applies to his client's case. So if I can get an ALJ in for that March date, I will definitely do that, and then we can just handle it that same day.
Well, Ron, if you can get those documents sent out to the board members, then we can, just like you said, we'll have it reviewed just kind of like we do our legal report and have an opinion by the time we get there.
Absolutely. Thank you.
Thank you. Keith, go ahead, buddy.
Make a motion to adjourn.
Second. All in favor, say aye. And this is Ronnie. I appreciate everybody being on the phone call today. And y'all be safe with all this bad weather y'all got up there by y'all.
Yes, thank you all very much.
Bye-bye, y'all. Have a good day.
Bye-bye.